right, let's see. We hit the buttons. Is it working? It looks like we're up and running. Good morning. Happy Friday. Hope you guys are doing well. It's going to be a good day. It looks like everything's good. Chat's up. Awesome. I like it when things work. That's awesome. Okay, so we got a lot to go through today. So obviously you guys saw the original thumbnail. We're going to be talking about the WFG contract. And I think that's only fair. We went through GFI's contract. Nothing super crazy or specific in that one. So I think really the only main thing that I thought was kind of interesting was that they include prospects in GFI's ownership, basically in that if you prospect somebody, that's also property of GFI. So if you leave, you can't even talk to your prospect for 2 years after leaving. So, you call your cousin or whatever and you try to sell them a policy, it's not time right now. They include that in there. So we'll see what WFG has in their contracts if there's anything that's crazy. I haven't gone through all of it. I kind of just skimmed so I knew where things were at. And we'll kind of read that together. And they always say nobody reads their contract, and it's one of their big selling points, GFI the whole time, or these other guys, EXP or not EXP, Experian, whatever it is. Oh, you don't read your contract. So we're going to read it together. You can be one of the few people in WFG that actually knows your contract. So we'll go through that together. It's about 100 pages. Not just the contract, but the things that they send out, the WFG kind of flyers and like best operation, best ways to do things. So we'll go through that. It's number one. Number two, we got a reply from WFG on the motion to compel arbitration. I don't know if we'll have time to get into that. I hope so. I'm hoping this doesn't run 2 hours. So we'll see if we can get into that as well. And then on Wednesday, if you remember, we already went through a lot of the arbitration stuff. So this whole trying to figure out whether this should go into arbitration, and if it does, it applies more to the rules of Georgia. So we'll see a little bit more of that in the WFG's contract as well. And I just want to say thanks. You guys have been awesome. We've gotten a ton more supporters over on Locals. So go check that out, just mckenzylong.locals.com. You can see all of this stuff. You can read along with it too. I try to post everything that we're going to talk about over there. So if you want to open up the WFG contract and go through it with me, you can do that. You can download that. GFI's contract is over there, their EMD contract. So basically everything that you want is over there. Until people start doing stupid stuff with it like they did before, then that might have to be put behind the firewall. Watch out for that Life 180 guy. If he starts making up stories about things, we might have to put that behind the firewall too. But then also, if you want the extra things, you can get all of the court documents by actually becoming a supporter. It's like $25. I think I'm in these court documents $1,000. So I think $25 is pretty fair for you to get in there, and you can download whatever you want, and it's correlated to each one of the videos. So we'll do that as well. And I'm excited. I probably shouldn't announce it, but I don't know. I have a hard time. Marlene woke me up super early this morning. She took a pregnancy test and it was positive, so we're excited. We've been working on that for like a year and a half. It's so tough when you're praying for stuff and it just doesn't happen. So anyway, we're excited about that. Probably way too early to get excited. And do you guys have that issue? I know, we'll get into it, I'm sorry, but do you guys have that issue? I feel like being in business so long, I have a hard time of getting excited about things because, you get disappointed 90% of the time. That I try not to get excited until it's actually done. Like, show me, like, let's actually do it first. And I don't know if you guys have that, but anyway. So let's hop into it and let's bring this up and we can start talking about the agent agreement. So, all right, again, this is kind of long, so we're gonna bear through it. There's a lot of different stuff in this. This is all the different parts of the packet. The main one that we're gonna be going over is the kind of the agent application. We'll run through the other ones. And again, this is on Locals. So if we skip something that you want to read, download it over there. You can go through it at your leisure if you want as well. But this will kind of go through. We also already went through the arbitration one, but we'll kind of just read through that again in case you missed that. But you can go watch the video from Wednesday. It's in there in its entirety. So, all right, let's get into it. We're also going to kind of bounce through this fairly quickly in a lot of these definitions in the beginning. So I apologize if you're brand new to the industry and you're watching this and you're trying to figure out if you should start with WFG or another company. You might want to read some of these things as far as understanding like what an advance commission is and that kind of stuff. But I think most people watching this video now are probably familiar with most of this stuff. So we're not going to spend a lot of time on these definitions just because we got a lot of stuff to get through. But you can read, they go through in each one of these things, they kind of have definitions for it in case you're not familiar. But again, I think almost everybody watching this is probably familiar with most of this stuff as far as what compensation is. Let's talk a little bit about confidential information because this is going to be big with the whole trial with GFI and WFG, right? There's this debate about confidential information and what it is, right? And it's funny because the Olsons and GFI say when they have stuff, it's confidential information that they don't want to give to WFG. But when they have access to it in WFG, it's no longer confidential information. So it's kind of weird how that works, and they kind of play both sides as far as that goes. But any and all personally identifiable information or confidential and proprietary records, data, or information created by or on behalf of or belonging to WFG and now or hereafter acquired by, made known, or disclosed to agents or any assistant which has value to and is not generally known by competitors or potential competitors of WFG. So information that a competitor or potential competitor wouldn't necessarily have is going to be considered confidential information and includes but is not limited to hierarchy lists, which we know that they've used to target agents and kind of go after that. I got a message from a guy a couple days ago who's asking me what he should do, and he's a WFG guy. He said that GFI has stolen basically all of his guys, and so now he's asking me what to do. And unfortunately, I can't give legal advice, or I don't really know how to help with that. But it's like, look, you either stay and you kind of fight it out and you help WFG with what's going on, or you ask them if they're going to give you your team back if you move over. And I understand you got to make that consideration based on you and your family and what you need to do. It's tough to lose your income like that, and this is why I hate this whole process, and I wish it would have been done an entirely different way. But we're here now, and so now we got to kind of figure that out. So if that's you, I don't know, you just got to kind of make that decision on what's best for you and your family. I know that sucks, but it sucks also too that GFI can do that and put you in a position that's like that. And I don't know, for me, I don't know if I could follow somebody like that, because who knows how many times it's going to happen again. And that's why we have these contracts, is so that this stuff doesn't happen that way. So it's unfortunate, but we're bearing through it. So personally identifiable information deemed to be confidential by applicable federal, state, commonwealth, and local laws, which includes lists of WFG agents. We know they've taken those as well, including their identities and contact information, which obviously they have. Right, that's how they were targeting people. So exactly like this guy who just messaged me, if you don't go, they go after your team, which is same as going after your income, and then they move those guys over, and then you're kind of in that situation where what do I do? And they can do that because they have these people's confidential information. They have their phone numbers and addresses and all of that stuff. Confidential information does not include information which becomes generally available to the public, other than as a result of disclosure by the agent. So if you had access to a hierarchy list for whatever, and then you publish it on the internet, it doesn't now make it not confidential information just because you disclosed it. So any assistant or any member of WFG's network of contractually, so just because it gets released to the public doesn't necessarily make it non-confidential information. If it falls within these statutes, then you're not really supposed to have it. So anyway, that's in the contract. So the Olsons, GFI should be pretty familiar with what confidential information is. They restated in the lawsuit as well, but they still seem to have an issue with figuring out what that is. So divestiture, hierarchy, you guys are going to be familiar with all of this stuff: overriding compensation, pending commissions, points, Trade secrets. Let's see if there's something in there. Any and all information, knowledge, or data in any form whatsoever, tangible or intangible, which is considered a trade secret under applicable law. I don't know if that's necessarily helpful. Agents, representations, warranties, and obligations. All right, so let's get into this. Actually, is there anything under vested here? The right of an agent to receive after termination an agent's contractual relationship with WFG such earned commissions based on sales made prior to termination, as permitted by law and agent guidelines unless until divestiture occurs. So they do have their vesting schedule. If I remember correctly, you guys correct me in the chat if you can. I think that's at SMD, right? And for GFI, vesting I don't think was until EMD. What they have is what they consider their EMD, which I think was 20 licensed agents, almost double the production of SMD in WFG. That might have changed, I don't know. Please correct me if I'm wrong in the chat, you can put that in there. So agents, representations, warranties, and obligations. So let's get into it. All right, agent hereby understand, agrees, represents, warrants, and acknowledges that agent is of legal age in the state of their commonwealth in each agent resides on the date that the agent signs the agreement, so you have to be over 18 years old, and otherwise competent to enter into this agreement and has the authority to enter into this agreement, and that by virtue of entering into this agreement and consummating the transaction contemplated hereby or otherwise, agent is not and will not be in breach of, violate, interfere with any other contract, agreement, business, or relationship or obligation which agent has with any third party, company, agency, association, firm, person, corporation, or other entity. Agent hereby confirms that the agent is eligible to work lawfully in the United States. So I believe you do have to have a social security number. Agent covenants that will not exceed our limitations or restrictions of performing services hereunder. Agents should hold harmlessly and identify WFG and its affiliates, their respective directors, officers, employees, and agents of any damages or legal fees arising from or related to the agent's breach of the covenant in this section. So if you break the covenant, you can't then go potentially sue WFG and the other providers. Agent has not engaged and will not engage in any business, practice, or behavior or take any action which has resulted or will result in any violation of any restriction or covenant of which the agent is subject pursuant to any agreement. Agent shall comply with all applicable anti-money laundering laws, rules, regulations, and government guidance, and according to reporting, record-keeping, compliance. These include requirements to identify and report current transactions, suspicious activity, which we'll get more into in the anti-money laundering section, I'm sure, to verify customers' identity and to conduct customer due diligence, know your customer. In addition to applicable laws, WFG and each product provider has implemented an anti-money laundering program, which includes requirements for reporting suspicious activity and requires insurance agents to complete anti-money laundering training. Agent agrees to comply with WFG and each of their product providers' anti-money laundering policies and reporting and training requirements. It's a huge deal. Have to have your anti-money laundering. Agent shall comply with all anti-corruption laws and will not make any bribes or engage in any other unlawful and improper methods to any person. Agent also agrees to immediately report to WFG any violations of the anti-corruption laws or suspicions that improper conduct was engaged to obtain business, and understand that WFG prohibits retaliation in any form against any agent who has in good faith raised or reported such violation or conduct. Agent agrees that by signing this agreement, agent is certifying compliance of WFG's HIPAA laws, their BA laws, both attached here in Exhibit A and Exhibit B. We won't go through that in depth. HIPAA is its own stuff. We'll talk mostly about WFG. Such exhibits may be amended from time to time with WFG without notice, subject to Section 6.1 or 6.3. Agent further acknowledges agent's understanding and agreement to the separate standalone mutual agreement to arbitrate claims agreement that follows this agreement. Okay, so I think this is what they're talking about in the lawsuit, right? So it says that you're agreeing to this and you initial right here, but then the arbitration stuff, we're on page 5 right now, is not until you get down to, I don't know what page this is. This like, do we get to it? Oh, here it is. So this is page 95. So you've got to scroll 90 pages in order to see this. And apparently in some states, that makes that agreement not applicable. So what do? You stick it in the middle of this, like right when they have to sign to it, they also have to read the 5 pages of arbitration stuff. I mean, I don't know. It's all together in one contract. I don't know. Obviously, they're using that just kind of as to get out of it, but it's part of it. So it is understood that in agreeing to provide services to an agent under this contract, agent shall be acting and shall always act as an independent contractor and not as an employee of WFG, right? And so we've had some debate about that in the GFI lawsuit as well, in that, are you an independent contractor or are you an employee, and how is that kind of defined? So they define it here. Obviously, for the lawsuit purposes, they're going to want to say that they were more of an employee than an independent contractor, but or its affiliate companies for any purpose whatsoever, including without limitation for purposes relating to taxes, payments required by statute, of any other withholdings and remittance of any government agency or authority. Neither this agreement or relationship created between the parties pursuant to this agreement, nor any course of dealing between the parties is intended to create or shall create an employee relationship. So it does not create and shall not create an employment relationship, a joint venture, partnership, or any similar relationship. Agent does not have authority to bid WFG in any contractual obligations outside of the authority described in this agreement. Agent shall conduct and control business activities, including but not limited to schedule, work hours, customer prospects, office location, geographic area, assist and administrative support of any expenses, business strategy and methods, subject to all applicable laws and Commonwealth. This agreement and any other contract between the agent and WFG, so far as it is not inconsistent or in conflict with the terms of this agreement, agent is free to engage in any other remunerative contract, calling, or occupation during the duration of this agreement, which is kind of unique. I know it's not that special today, but this is still kind of special in our industry, that you can still do other stuff. It's one of the few places, like most, a lot of insurance companies, like you have to go full time. It's commission based, you still got to go full time, do it full time. They give you the ability, and I know it's weird because a lot of times your faults are what your strengths are what people consider your faults sometimes, right? Like if you have a unique look to you, people kind of make fun of that because it's unique, it's different. This is one of the areas where industry gets made fun of the most, but I think it's one of the coolest aspects of it is that you can be a doctor, engineer, whatever, and you can start your own business. You can start to be a part of a company, GFI, PHP, whatever, but you can do it part-time and you can build it without having to lose all of your income. It's kind of, it's very rare. You don't see that very often in a lot of businesses or a lot of industries. So anyway, 2.8, the parties shall operate their respective businesses separately and independently of each other throughout the duration of this agreement, subject to required insurance industry regulatory oversight from WFG. None of the benefits, if any, WFG provides to its it's separate, to its employees, right? Because WFG does have employees, right? Home office, that kind of stuff, shall be available to the agent. This includes benefits, employee benefits, pensions, profit sharings, stock options, health insurance, dental, disability, workers' compensation, bonuses, vacation pay, right? And this is common even in a lot of the businesses that we work with that have employee benefits and that kind of stuff. Their 1099 guys usually don't get any of that stuff, right? Because they're independent contractors. You can generally make more money, so you got to kind of come out of pocket for a lot of those things on your own, because you're not an employee, right? Whether or not reduced to writing, agent agrees that, if applicable, it is the sole responsibility of the agent to purchase workers' compensation insurance or file any related notice of designation as an independent contractor or similar paperwork with appropriate state or commonwealth or local agency. So if you have your agency, so like we've hired assistants before, you have to have your workers' compensation and all of that stuff in place to legally be able to do that. So they're just kind of saying you have to do that. So the agents shall procure and maintain all insurance coverages and permits of work of every nature and kind required by state and federal local laws. And the agent shall have no recourse against WFG or its affiliated companies for any loss, damages, claims, costs, expenses in relation to any occurrence connected with the services provided under this agreement. So basically, if you rent an office, right, you can't sue WFG for losses or damages. I'm guessing that kind of happens with that. WFG's request, this agent may be required to produce WFG as a WFG clearance certificate or other documentation demonstrating that the agent has adequate workplace safety, insurance compensation, and other insurance coverages. Agents shall not have the right to select and engage. Agents shall have the right to select and engage assistants to assist with the accomplishment of work. Obviously, yep, you can do that. So you can hire assistants if you want to help. There's so much back office paperwork that happens. Surprisingly, you would think everything being digital, it wouldn't happen, but following up with providers and doing all of that stuff. Agent is solely responsible for paying all compensation owed to any assistant. Remit the appropriate government agencies, any applicable taxes that might be owed with respect to such compensation. Agents shall be responsible for the activities of any such assistance, the same as if the activity was performed in conduct by the agent directly, including but not limited to any assistance, protection, or use of confidential information or trade secrets. So you can't pay your assistant to go in and get all of that confidential information. It doesn't make it non-confidential. It's still confidential. They're an extension of you. Agent authorizes and acknowledges that all compensation owed to any agent as a result of business written and referred by an agent shall be paid to the agent by WFG, and that product providers have no obligation to the agent for compensation on such businesses. So, meaning when you work for WFG, even though you might write a policy with Nationwide or Pacific Life, they pay WFG, then WFG pays you, so you wouldn't go direct to that company to try and get your payouts because it goes through WFG. All amounts earned in connection with the business written or referred by an agent while this agreement is in effect shall be paid by product providers to WFG as long as the contract or policies remain in force and subject to commissions payments, and WFG will pay the compensation to the agents I should just finish reading instead of adding my 2 cents. The compensation paid to the agent from the sale or referral of the products and services is compensation for the agent's sale or referral, his or her downline, or referral of products and services, and the agent's agreement herein not to breach the terms of this agreement. So you only get paid. A lot of those people say, oh, well, you get paid to recruit. Not really. You get paid by having more production in your agency, but you don't get paid directly to recruit. So agent sale or referral, so you sold something, you referred it personally, your team did, or they referred products and services, how you get compensated. So while this agreement is enforced, the agents shall have and maintain appropriate insurance license. So you have to be licensed in the state that you actually sell products in, the one that you live in. And sometimes, weirdly enough, if you meet somebody in like a third state, I don't know why that would necessarily happen, but sometimes you have to be licensed there as well. As required, applicable to the business agent conducts under this agreement, not have any affiliation other than as a customer with WFG product providers outside of his or her relationship with WFG of any sale. So basically, they don't want you working through WFG and then also selling direct for Nationwide, let's say. Like they would want you to go through that relationship that they have, unless such affiliation is a receipt for vested or deferred compensation, earned trails, and renewals only. So maybe you already had a book of business. A lot of times you'll see people come from other places in the industry, and so they might be receiving a compensation outside of WFG, so you can keep all of that stuff. What they don't want to happen is selling away, basically, especially when you get into the security side. They don't want you talking about something in what looks like. So imagine somebody walks into a Transamerica office and you're selling products and services, but then you sell something else through the back door with another company. They don't want that stuff to happen. You're not legally allowed to do it anyway. So that's basically what they're talking about here. And they just want that stuff disclosed in writing. So not to be obligated to contract with WFG, you're not obligated to contract with WFG exclusively, and this agreement does not have agent exclusive rights in any area, and take responsible actions to monitor and supervise and recruit and sell activities for their downline agents and ensure that their downline agents are following the terms of the agent guidelines. So this kind of comes into question too, right? If part of your responsibility in being an agent is helping your downlines understand and abide by those, and then you're teaching them how to do the anchor leg strategy, right? So you're guiding them to break their contract. Do you become liable for that? Here it kind of looks like it does. If you're responsible to take responsible actions to monitor and supervise the recruits of selling activities of their downlines and ensure their downlines are following the terms and conditions. Or the other thing that we heard of in that anchor leg strategy is you're teaching them to have the front of WFG. You're acting like you're selling a product or service, and then you're selling it through GFI. You're not acting in good faith as an agent. If you're contracted with WFG and you're teaching people how to do this stuff and move stuff over, is there additional stuff that can happen to you as far as that goes? That'll be interesting to see in the lawsuit as well. Except as prohibited by law during the period that the agent is an agent with WFG in a period of 2 years. Okay, so this is going to be an important one here. This is what they keep talking about in the lawsuit. So except for prohibited by law, and maybe that's the part that the lawsuit is hoping to find, right? Take another shot at 16600, except for prohibited by law, which in California apparently, depending on how you look at a non-compete versus a non-solicitation, but basically for 2 years following the termination of this agreement. So even after you leave WFG, for 2 years, for any reason, the agent shall not, either individually or in partnership, and this becomes the second question, right? Because Welsh and Cofield were basically saying, they were saying that they were the ones that were doing it. But Olson was kind of behind the scenes, and so he wasn't really seen doing some of these things. They were the ones going out and doing that. But if you can't do it even in partnership or jointly or in conjunction with any other person or entity, I mean, I don't know how you would prove that, right? Other than some of the comments that people have made, like, hey, how come Olson's not on these trainings with us? And they're like, oh, well, he still has to be behind a camera for the time being. Well, obviously, because it's still within that 2-year period. So as a principal agent, consultant, contractor, employee in any other manner, directly or indirectly, you're not supposed to solicit, induce, or entice away, or in any other manner persuade or attempt to persuade any individual who is current agent of WFG and with whom the agent has had business contact with on behalf of WFG, its affiliates, or related entities. You're not supposed to tell them to terminate their contract or alter their agreement relationship with WFG, to join a competing organization. This non-recruitment restriction, so they call it something even different here, is limited and only applies with respect to any recruitment of any agent that resides in or engages business and activities in the geographical area within 50 miles of the location of the agent's office during the 18-month period preceding the recruitment. This provision survives the termination of this agreement. So, which I still don't understand too. I mean, I guess most of Olson's business is within 50 miles, I guess, but he's got people all over the country. So I think he could have easily like gotten around this as almost a right? Because 50 miles now is not a big deal with what's happened through COVID and using Zoom. So he very could have easily just not like solicited those people in within 50 miles. I think he's in somewhere San Jose, somewhere up in that area. Just don't do 50 miles from there. Recruit the other 90% of your people, I guess. And then after the 2 years, or even as you're bringing those people over, if they come with it, I mean, I don't know if that's really the limitation. That's kind of interesting too. Would have been easy to get around without having to cause all this hoopla. Agent will not use, disseminate, or reveal on behalf other than on behalf of WFG's authorized by WFG's product provider any confidential information. So unless WFG gives you permission to reveal that confidential information or trade secrets or the product providers, which agent hereafter receives, agent agrees that immediately upon the termination of this agreement, agent will return all documents, files, and lists containing any confidential information or trade secrets, and the same shall not be copied or duplicated. I don't know how relevant that is anymore since everything's online, but still, you shouldn't. If you have access to it online, you shouldn't print it out and then keep it, I guess is what they're saying after that. So, agent shall not do anything that will damage the business, good name, or reputation of WFG, its affiliated companies, or other respective officers, directors, and employees. And this is another one that they're talking about in the lawsuit, because obviously there were a lot of alleged falsities that came along with this whole process, which I understand, right? Like, you gotta motivate people, and it's easier to have a bad guy to fight than it is just say, hey, we just feel like starting to do something new. Do you want to come with us? So much easier to vilify one and then move over. And unfortunately, you see people do this with clients as well, which I think we'll talk about. I think there's some provisions about that later, which you're not really supposed to do. Some companies are terrible about that. But agent also shall not, in connection with any other personal entity or joint activity, venture, or corporation, appropriate or use WFG's affiliated companies, service marks, trademarks, designations, labels with terms WFG, World Financial Group, Transamerica, Aegon, or similar designations or derivatives, whether separately or in conjunction, which is interesting, right? Because it's funny, we'll see another provision. I think there's one in here that says you're not really supposed to use your team names on social media and those kinds of things, but then you're also really not supposed to use WFG because you're not a employee of WFG, right? Like, if just because you put out content doesn't mean it's approved by WFG, right? Like, you're doing it as your own. So normally you would use some kind of team name or something to signify who you are or whatever, but you're not really supposed to do that either. So it's kind of this weird area in the industry, and I don't know if that's because they're securities licensed as well, that you're not really supposed to use WFG and Transamerica, but then you're not really supposed to use your team name either. So I guess you just have to represent yourself, which is tough when you're building a big agency, and that's why you see things like Pinnacle and that kind of stuff as well. So kind of a weird gray area in there. Agent shall and again, I don't know. I guess it also depends on how much it's enforced, right? Like, we have weird laws on the books sometimes, but nobody applies it, right? So it's like, how valid is a law that nobody actually applies? The border right now, right? So you might have laws in place, but if you don't apply them, are they still laws? I don't know. Agent shall comply with all terms and conditions in this agreement and other contracts with WFG. Agent guidelines, all policies, practices, procedures adopted by WFG and are mandated by law, regulation, administrative bulletin, questions and answering, binding industry requirements, specifically including insurance and data protection requirements. And again, agents shall take responsible steps to ensure that any assistant also complies with those, except as prohibited by law. The following terms shall apply. Agent shall promptly pay, including through offsets against pending commissions, all expenses related to this agreement, including but not limited to indebtedness to WFG or affiliated companies. So if you're kind of new, because Some companies in the industry pay out advanced, meaning they might have received no money yet. Let's say somebody starts policy with Nationwide, they might not have, or they've received the first payment basically. Let's say it's $200. They're going to pay you for the year of that policy, and they've received one payment so far. So if that policy doesn't stay for the year, you might have some indebtedness there, basically a chargeback. Agent shall, so you're obligated to pay those. And what's nice is they don't come, at least I don't know of too many companies that go into your bank account, right? Like it just kind of sits there and holding, and then as you work that off and you continue to sell policies, it gets paid off on its own. Debt balances of any agents of your downline agents roll up. So if a downline agent leaves, they can potentially leave some of that stuff to you. Sometimes they'll go after them too if it's a big balance, to make them pay it back, which is helpful. Technology fees, system technologies provided, right? Because you get CRM, you get access to all of the online stuff. So I think that's like 15 or 25 bucks that they charge there. The agent hereby acknowledges that any required fees relating to such services may be charged by WFG without prior notice. Agent hereby agrees that WFG to apply offset against agent's pending commissions for the payment of agent's expenses. Agent shall participate in WFG's established program for errors and omissions. So you have to make sure you have that. And you have to keep proof that you have it, kind of like with your car insurance stuff, right? Agents shall be responsible for providing agent's own office, telephone, furniture, supplies, transportation, and other facilities, right? Because you're an independent contractor, you're a business owner, if you will, so you incur those costs, and you've got to take those on for yourself. Agent shall be responsible for ensuring the accuracy of any records, calculations, correspondence that the agent receives from WFG. If the agent identifies an error or inaccuracy, they've got 30 days to report that. If the agent does not provide notice within 30 days, receipt of records, calculations, correspondence, such record, calculations, correspondence shall be deemed as accurate to be binding upon the agent. WFG shall be released from liability of those or responsibility of any manner of those, notwithstanding the forgiving WFG identifies any error in inaccuracy in any record, calculation, correspondence with the agent. Agent agrees that any and all personally identifiable information collected, stored, transmitted by the agent or their assistant, if any on behalf from WFG and their product providers with performance of agent services under this agreement, shall be used only as necessary to perform the agent services under this agreement. You're not supposed to collect, access, store, transmit, or otherwise disclose people's personal information, right? Because you're getting their socials, you're getting their address, you're getting all that stuff. So don't use that in any way that you're obviously not supposed to, or any person other than WFG product providers or individual who is subject to that, specifically authorized to write by WFG product providers or any individual or otherwise permitted by law. Agent agrees to establish physical, electronic, and administrative procedures to protect the security of that confidential information, that's important, right? Like, don't just leave social security numbers laying around in your office. Agents should comply with terms and conditions and restrictions as conveyed through training, information made available from third parties, general industry standards, use of WFG's licensed computer software. Agent further agrees to comply with terms of any licensing contractual agreement that the agent has entered into with such third-party software providers. In connection with any payment or amount that WFG or the product providers may refund to any customer, WFG shall be authorized to deduct that amount of any previously received compensation. This is what we call a chargeback. Agent shall repay all indebtedness upon demand by WFG. Any balances not paid within 30 days of the date of the demand. I don't know, I've never really seen that happen in the industry. Do they do that? Where they just demand that you got to pay it now? Usually they let you pay it off over time. Indicated in the agent agreements, such interest shall be added to the debt balance, offset by future commissions. You guys get that. Agent guidelines will be set to establish a fund reserve balance to be used to pay off any future outstanding debt balance at the time of the termination. So just because you get terminated or you leave, you still have to work on that balance. By entering into this agreement with or otherwise becoming an independent contractor with WFG, agent expressly consents to being contracted by WFG and its agent representative third-party services are contacted, so they can reach out to you, you give them permission to email you, send text messages, whatever. This provision survives termination of this agreement, so they might still have you on their list and contact you afterwards, even if you were terminated. So that's fine. Agents shall cooperate fully and provide assistance to WFG in the Okay, interesting. So you're supposed to assist in the investigation and resolution of any complaints, claims, or actions or proceedings that may be brought by or may involve agent or agent's hierarchy or WFG. So I wonder if that kind of pertains here too, with what's going on with Eric. Agent shall not take or perform any act or action or make any representation purporting to create an obligation or liability on the part of WFG. This is a big one that people have a weird thing with. For instance, like if you get an office, you're supposed to put it in your name. If you, or your business name or whatever it might be, because it's not WFG's phone bill, right? Like it's yours. So, or Nationwide or anybody else's, it's yours. So don't put that, you don't create an obligation for them. And people go, well, but I own the business. Why can't I do whatever I want? It's like, it's true, but you own it, so put it in your name, right? Don't put it in their name. Directors and employees are binding of WFG or its affiliates. Do not collect cash. Yes, it's a big one. Don't take cash or checks from a customer in payment for the purchase of products or services payable to any person or other than the party designated by the appropriate provider. Yeah, if you're having people write you checks, that's a big no-no in the industry. Don't do that. Or you're commingling funds, not good. Don't do that. Represent a product. Do not represent a product or service that is not a product or service under this agreement and has been approved by and offered for sale through WFG, right? Don't sell outside. Okay, sell or refer or offer to sell any products or services through WFG that is not, okay. So I got confused there for a second. So you can offer other products and services, right? Because they say that you're not subject to only working with WFG, you can do other stuff, right? So that would open up the door that there might be other products or services that you offer. Maybe you're, you do estate planning or something like that. They're not saying that you can't still do those. You just can't say that you're offering it through WFG that is not a product or service under this agreement. So don't come forward like this is something I'm doing through WFG. This is something I do outside of that. You just got to be specific of that. Make any misrepresentations to a customer in connection with referral or purchase of or proper imprudence of any customer to purchase products or services. Agent shall indemnify WFG and hold any indemnity parties, third parties harmless, which opens up another question too to the anchor leg strategy, right? Because if they walk into your office and you're with WFG, your spouse is with GFI, right? And then you're telling them that you're going to give them an insurance policy, but you sell them GFI's insurance policy because you're in the process of moving everything over. You're not really supposed to be doing that, because what the customer sees, like if you put them in their shoes, like if you walk into Foot Locker, you think you're buying something from Foot Locker. If they were then selling you shoes from, I don't know, one of the other shoe places, you would go back to Foot Locker and say, hey, I had this issue. And they're like, well, where's your receipt? Your receipt says that you bought shoes from over there. So it confuses the customer, which is really kind of crazy when you think about the anchor leg strategy and what they're doing with that. Is those people who are straddling the fence, if they're still meeting people and they see online you're with WFG and your office is labeled WFG, they're coming in, they're sitting down, they think they're working through WFG, and then you're selling GFI or another company through that, you're breaking this contract, even another stance. And I don't know if they're educating their agents who they're telling to do these things, how many parts of that contract they're breaking. But I guess according to Eric, it's all restrictive covenants and it shouldn't exist. You should just be able to do whatever you want to do. So upon termination or request, agents shall return all WFG property, and acknowledges includes all customer and other files in the agent's possession. So, all All right, agent compensation. Agent acknowledges and understands that agent is compensated under this agreement only from the sale or referral of products and services offered through WFG by the agent or within your agents. Wow, that was terrible. I completely just like wrote over the whole thing. So, or the agents in your agency. The agent's sole compensation, so no, you don't get paid for recruiting. You can recruit all day long. If nobody sells anything, there's no products and services sold, you won't make any money. So, which is a good thing, right? That's how it should be. You shouldn't get paid just purely to recruit. Then it'd be some kind of pyramid scheme, which obviously it's not. So there, you actually have to service a client in the process. And dig in term agreement shall be that compensation paid or caused to be paid by WFG pursuant to this agreement, agent guidelines and or selling agreements between WFG and the providers. There is no guarantee that the agent will be financially rewarded solely by the virtue of becoming an agent. This, like, I think we need to, in our industry, be stronger with this. It should probably be at the title when they sign their AMA, right? Because you get this all the time. It's like, been recruiting in the industry for a long time. There is no guarantee that the agent will be financially rewarded solely by the virtue of becoming an agent with WFG or by attempting to build his or her own business. So if you don't do anything, I'm sorry, I know this is what a lot of people who come into this, because I think it's something what, like 90% of people don't actually even get licensed. So I don't know what they expected to happen, and maybe this is an issue with the agents, but I don't know, having done it long enough, I think it's an issue with people, is that for some reason they think they just, by signing an AMA, you should somehow start receiving money into your bank account. It's not how it works. If you buy a McDonald's and you never open the doors, you never sell a hamburger, sorry, you're not going to make any money. It's just, that's actual business. That's how it works. Maybe people want it to be a pyramid scheme, but they hope just by signing up, money's going to show up. But then they reluctantly find out that it's not, and that's kind of a brutal thing, I guess, if you're just hoping to do nothing and get paid. Except as in set forth in this agreement or the agent guidelines, agent shall not receive any other compensation or benefit of any kind whatsoever, including but not limited to insurance benefits, workers' comp, etc. Under this contract. Commission is not considered earned by the agent and due and payable by WFG under this agreement. Earned commissions unless or until. So how does it become earned commissions? The agent has a valid license, an active agreement with WFG at the time of the payout or otherwise vested. So obviously, if you try to sell a policy and your insurance license is no good, obviously you're not good, which I think is the second thing, right? The other thing that happens if you never get licensed, how can you expect to get compensated? You literally have to have a license to get paid on any of this stuff. So just so weird. I mean, I guess it's the same thing. How many people sign up for the gym in December and January and then never actually go to the gym again? I think it's something like 90% of gym's income is from people who never actually step foot at the gym. In fact, I need to go talk to them and tell them I haven't lost any weight for not showing up. I need to go see somebody in person for that. So WFG has received payment from the product provider on the commission or sale. All requirements set forth in this agreement are satisfied and the commission calculation is finalized. So A, you have to have a license in place. WFG has to receive the compensation from the product provider. You have to not have broken any of your restrictions in here. And then the commission is calculated, finalized, and you get paid. So the commission's calculation is not finalized until the calculations are set forth and the agent agreement are completed. Subject to any applicable law, any monies, fees, or points owned by the WFG agent, actual or contingent debt balance, and any money or points which have been advanced or credited by or on behalf of WFG or its product providers for the benefit of the agent may be offset or deduct WFG from any pending commission payments. So again, yeah, let's say you have a chargeback and you were supposed to get paid $1,000. The person, after the policy goes in place, decides that they don't want it anymore, or they talk to a Primerica agent and they tell them to do something stupid, which happens. They talk to their cousin who's broke living on their couch and says that insurance is stupid, so they cancel it. Well, they won't come in and take that from your bank account. It's going to go into a balance, and then as you're working that, it'll go into paying that off. Agent authorized affiliated companies to pay directly to WFG any pending commission. So you're authorizing Nationwide to pay WFG, and then WFG is going to pay you in that structure. Any damages or losses, they won't be responsible, except as otherwise prohibited in this agreement, is subject to the terms of this section if and when an agent qualifies for and attains certain hierarchy level designations established by WFG from time to time pursuant to the agent guidelines. Agents shall become vested and entitled to continue receiving earned commissions after termination from WFG. So I guess this kind of goes into that whole question of, do you have ownership of your business? I mean, it looks like it. Obviously, you have to become vested, I think, is SMD. Correct me if I'm wrong. But I think it's MD. Isn't it MD? Once you become vested, well, then you earn your commissions even after you might leave WFG and you're terminated from them. So subject to all applicable laws, including but not limited to rules or regulations. I think you still have to keep your insurance license, but yes. So agreement if agent becomes vested, then in the event that this agreement terminates due to the agent's death, right? This was another question they had. They said that WFG will not pay out your commissions if you die. WFG shall pay the commissions to the agent's estate or agent's beneficiary as designated in writing by the agent's estate representative at the time of death. Agent shall, upon becoming vested, be vested only in the extent that WFG receives payments from the product providers. Obviously, yeah. So if they don't receive a payment, obviously you're not going to. The commissions are earned commissions as set forth herein, and the agent can legally receive such amounts. So according to WFG's guidelines, it's right here. I don't know why, unless Olson's saying that they're just not doing that, but I mean, I haven't seen any evidence of them not following their own rules. But at least because it's here, if they didn't, you could take them to court and they would then obviously have to pay them. It would suck to come out of court costs. But it says right here that they will pay upon death, and I've never seen anything otherwise unless you guys have something. In the event that an agent at the time of termination of this agreement has not qualified and attained the sales position designated established by WFG according to becoming vested, the agent shall have no right to any of the pending commission, earned commissions, or other compensation of any other kind from WFG after termination. So I guess there's maybe a point there that you do obviously have to become vested. And I think it's EMD, or sorry, it's MD. Correct me if I'm wrong on that. Notwithstanding anything in this, so if you just sign up, you do one policy, they're not going to keep track of that stuff. I don't know how much you'd actually make off of the residual on that. Probably cost them more to pay it out, get that check for 50 cents every year or something. So notwithstanding anything in this agreement, to the contrary, if the agent is vested but the agent's termination from WFG is for cause. Okay, so this is an important one too, 3.6. So if you're terminated for cause, which is what they're saying Eric Olson was, because he was with WFG, simultaneously with GFI, moving people over, breaking the contract of the things that we read earlier. You're not supposed to solicit people, you're not supposed to take clients, you're not supposed to have their confidential information and target people, you're not supposed to do all those things. So WFG is saying that it's for cause in accordance with section 4.3, which we haven't gotten to yet. Divestitures may occur in WFG's sole discretion, and the agent forfeits any right to receive earned commissions post-termination unless such divestiture is prohibited by applicable state law. So I guess that's where that 16600 starts to come in place. Does that make it a state law? Does that change something? Additionally, even if the agent's termination from WFG is not for cause, okay, interesting, termination in accordance with section 4, should agents subsequently violate or fail to comply with any promise, obligation, or covenant, or warranty, or representation continued in this agent agreement, should survive the termination of this agreement, such violation or failure could result in divestiture as described in the section unless such divestiture is prohibited by applicable law. So this kind of becomes the question of what happened when Olson was trying to leave the company, right? Because if they felt like he was going to break this contract, right? There's two ways that conversation could, I mean, there's a bunch of them, but two ways that I kind of picture it. One, he said, hey, I want out, but I'm getting out of the industry, or I want to start another company, and I'm going to do it entirely separate from WFG. I think WFG would have handled it very, very differently. Like they would have bought his code or allowed him to transfer it and do that. But if he went in there and said, I'm moving all of my stuff over, that to me seems more like the reaction that WFG had. And they're going, well, he's going to break this contract anyway, so why would we help comply with any of those things? Other than I think we would still be in the same exact situation, and WFG would have been able to save face a little bit more. But either way, I think we'd be in almost the same exact situation. As an independent contractor, agents shall be responsible for paying any and all federal, state, and local taxes that may become payable. FICA, Social Security, unemployment, you still got to pay all of those taxes. So at a certain point, you open up your LLC or S Corp, so that way you can help save some money on your taxes. Term and termination. This agreement shall take effect on the effective date and shall renew upon renewal by agents unless otherwise terminated in accordance with Section 4. This agreement may be terminated by either party at any time for any reason upon 30 days of written notice to the other party. Notwithstanding the notice provisions of 6.3, agent may also provide such termination notice to WFGs pursuant to agent guidelines. This agreement shall terminate immediately without advance notice in lieu of notice, damages, compensation of any kind. On the death of an agent, which we just talked about, where WFG determines in its sole discretion that it has cause for termination with the possibility of divestiture, shall include the occurrences of any of the following events. Agent's insurance license is terminated, so if you don't keep that active, you can become terminated. I shouldn't put a question mark there, that should be like a check mark. Agent is indicted with suspected trial for a conviction of a crime. So if you convict a crime, you could also be terminated, which makes sense because you would usually lose your license too. So disciplinary action is taken against agent by any state, federal regulatory agency, or body with jurisdiction over the agent, WFG, affiliated companies, or product providers. So again, yeah, if you were caught churning or something like that, WFG could terminate you as well for a cause. Agent becomes temporarily or permanently enjoined, censured, suspended, disciplined, or otherwise prohibited from acting as an agent with WFG or its product providers, conducting his or her business, or performing any of its services under this agreement, acting in any capacity in the insurance or financial services businesses that WFG considers in its sole discretion relevant to the agent's performance of the agent's duties under this contract, termination for any reason of the agent's agreement by any product provider, affiliated companies, expressly acknowledged and agrees that WFG may rely on the product providers, affiliated companies, or terminations in representing and reasons for termination of an agent. So I'm guessing, let's say you were with WFG, you forgot to tell them you committed some kind of criminal thing after you were with them, then you applied to get appointed with a company, and you told them, that provider found out, they then let WFG know, that could also be grounds for termination. So it doesn't really matter how they find out. You don't have to tell them specifically, but if that provider found out, declined you from becoming an agent with them, WFG found out about it, you could also be terminated that way. Agents' misrepresentation or commingling of customers' payments or funds, yeah, it's a huge no-no. You should not be receiving checks for anything. That's very, very bad. Engaged in any fraudulent act. Agent misrepresents the character or benefits of any of the product providers or services. Any interference with the collection of renewals or premiums. Agency violates any law or regulations that governs the conduct of any agent's business. Agent breaches any provision or fails to observe any obligation under this agreement or other agreement that the agent may have. now or hereafter with WFG, including without limitation, failing to repay debt balances or comply with other monetary obligations by the WFG agent in a timely manner. Agent agrees in any activity in which, in sole opinion of WFG, may adversely affect the good name and reputation of WFG or affiliated company. Yeah, like if you're out there partying and doing drugs, and you say you're representing WFG in that capacity, and doing things that you're not really supposed to be doing, and they find out that you're affecting that, I guess that's something they could do as well. So agent engages in any activity in which, in the sole opinion of WFG, may be detrimental to the business interests of WFG or its affiliated companies. Agent fails to comply with material aspects of the agent guideline as determined by WFG. Agent is determined to have made any false or incorrect statements in the application to a regulatory authority or WFG. So if you lie in your application of becoming appointed with somebody and then they find out about it, that can also be an issue. Failure to meet and maintain any background criteria set by WFG and the product providers. My gosh, how many background checks do we have to do in this industry? It's crazy. It's like 3 or 4 of them right off the bat. So because you get background checked when you when you get your license, right? Then you get background check when you get appointed with a company. Then you get a background check for each one of the product providers that you get appointed with. It's too bad they can't all just talk to each other and you could use the same one. But anyway, WFG's discretion to enforce its agent guidelines. Instead of immediately terminating this agreement, WFG may impose suspension. This was my question. Like, if you talk to anybody in WFG, Olson's been using the anchor leg strategy for a decade at least, right? So was there a single instance of a suspension or something in writing at all that they can refer to solicit or purchase referrals from the sale, solicit customers for product service suspension or loss of compensation? They can pause your compensation if it's more of a, hey, don't do that again. We got to kind of like slap on the wrist, but we're not going to terminate you. You just shouldn't do whatever it was that you did. Maybe you didn't know you acted involuntary, or it was kind of involuntary. You didn't mean to do it. In the event of termination of this agreement by either party, WFG shall be entitled to notify the product providers or regulatory bodies of such termination. Agent agrees that WFG shall not have any liability for any loss or damage otherwise resulting from the termination by the product. So if you do something stupid, it's not going to be WFG's fault, right? It's your fault. You're responsible for that. Upon the termination of this agreement, all compensation due agent as effective termination shall be paid to the agent in accordance with WFG's guidelines other than earned commission to which the agent may be entitled. If the agent is vested, no other compensation shall be payable to the agent after termination, divestiture, any clause of termination, this discretion of WFG. Any remaining balances will have to be paid off. The term and provisions of any paragraphs or section of this agreement which expressly state or by their terms require that they survive termination of this agreement shall so survive the termination of this agreement. Agents promise to indemnify and assign. You promise to hold them harmless in any way as they have to maybe collect a debt or remit payment on a timely basis. Agent further agrees to indemnify and hold the party harmless for against indemnity losses incurred, sustained, suffered, assets against the indemnified party arising out of or as a result of omissions of the agent's assistance, your downline, including breach of this agreement, any breach of contract within the product providers, including but not limited to misrepresentation involving whether the agent is authorized to act on behalf of the party or product providers, misrepresentation involving the offer, referral, sale, product, services, in defending or otherwise addressing any such claims. The identified party shall be entitled to use counsel of its choosing to determine the validity of those claims. To ensure the agent's promise of indemnification of the agent's obligation to repay any outstanding balances. This assignment is given to WFG to secure agent's obligations as set forth in this agreement. Agent expressly authorized WFG withhold pending commissions in connection with the indemnity obligation. So again, if you've got a balance, you're authorizing them to use new commissions to pay off any balances that might exist. Miscellaneous. WFG shall have the right to amend this agreement at any time by giving written notice effective upon minimum of 45 days notice, notwithstanding section 6.3, which we'll get to in a second, to provide and be posting the amendment of the WFG site. Agents' continued affiliation with WFG upon receipt of the notice of any such modification shall constitutes the agent's agreement. Okay, so this I think is kind of what they were talking about, right? Like if they change stuff and you continue to work with them, you're kind of agreeing to it in a way, right? Like you live in America. If they change a law, you are still subject to that new law. You may not have said, hey, you might not agree. Maybe you're like me, you don't agree with speeding laws, right? So you go, I never signed off on that, but your involvement in the country and being a citizen means you're automatically agreeing to what's in place. So WFG may, from time to time or without notice, increase or decrease the rates of the amount of commissions, including agents, including to provided herein that such changes may only be provided prospectively, and any such changes may affect only commissions paid on any new businesses. So they can't go back and change how much commission you've been paid. But let's say a product provider changes the amount of commission that they're paying, they're obviously going to adjust that for new business into the future. So all notices or demands hereunder shall be sent addressed as follows. If to WFG, oh yeah, so if you're writing to the president of WFG, this is how you should do that. If to an officer, director, or employee of WFG, this is how you should do that. To an agent, to their home address, email address reflecting their records. This agreement is not a franchise agreement and does not create a franchise relationship between WFG and an agent. If any section of this agreement is deemed to create a franchise between the parties, then those provisions shall be deemed void and unenforceable. Failure to delay by any party to insist upon strict performance in terms of condition of this agreement shall not be deemed a waiver of any subsequent breach or default of terms hereof. Any waiver must be in writing and signed by the party granting the waiver. Any waiver granted by WFG must be signed by an officer of WFG. Titles and headings on sections of and subsections of this agreement for convenience are not intended to encompass all of the provisions herein. In such part, section, paragraph of this agreement shall be found void or enforceable. Such filing shall have no effect upon any other part. So if the laws change and one part of it is not void, it doesn't mean that the whole thing is void. Agent may not assign any rights or obligations or delegate any services under this agreement except as expressly provided herein. Agent agreements and otherwise authorized in writing prior to WFG. WFG shall be released from all obligations and liabilities so assigned. This agreement constitutes the entire agreement understanding between the parties unless another agreement is executed by the parties simultaneously or with no subsequent to this agreement which makes specific reference to the agent agreement, while certain business activities of the agent may occur. Okay, so this is going to be another helpful one too as we move forward with the GFI lawsuit, which is interesting. So while certain business activities of the agent may occur outside of Georgia, the parties acknowledge that significant aspects of performance of this agreement will occur in the state of Georgia. Somebody the other day said, well, why don't they just put in there that you're subject to the laws in Georgia? And so it sounds like that is there. And that the provisions of this agreement will be governed and construed under the laws of the state of Georgia. I'm going to put $100 on this. I bet you it says unless you live in California, because California does whatever it wants to do. If conflict or choice of law rules would result in the application of the law of another jurisdiction, each party voluntarily waives such rules and agrees that the substantive law of Georgia shall nonetheless govern. Agent and WFG, without waiving their rights or relieving them of their obligations to arbitrate claims set forth in the separate standalone mutual arbitration claims agreement, voluntarily consent to the jurisdiction and venue of the Georgia courts with respect to any such dispute or litigation. But if agent, here we go, but if the agent operates in California, agent may opt out of this provision. Okay, so I guess key point for them there. In order to be effective, the opt-out notice must be submitted within 30 days of the receipt of this agreement. Yeah, I highly doubt that's going to hold. Agent must retain proof of timely submission of the opt-out notice. Agent acknowledges the right to consult with an attorney for advice considering this provision. Agent further acknowledges the opt-out notice does not impact the obligations to arbitrate claims set forth. So even if they opt out for another state, they should still have to go through arbitration. Standalone agreement in the arbitration claims, which we read last week. Agent further acknowledges this provision will not be agreed to as a condition of employment. Agent is an independent contractor and not an employee of WFG or its affiliated companies. Agent further agrees this agreement is not an employment contract. In the interest of maintaining safety and security of WFG's customers, employees, and property, agents agree that WFG shall have rights over such credit, employment, and other financial background investigations on the agent at the time WFG deems useful. Whether such investigation is conducted by WFG and or outside source, the agent shall provide any necessary consents to such investigations. So if they feel like you've done something wrong and they want to do another background check, they can do that. Agent further consents to disclose to WFG of such information of any product provider to which the agent desires to get appointed. As a condition to becoming an agent of WFG, the agent is not required to purchase any of the products and services. So here's another question, right, when they always try to relate it to some MLM pyramid scheme type thing. Well, you have to buy the products and services. So here's section stating that specifically. As a condition of becoming an agent with WFG, the agent is not required to purchase any of the products and services and is not required to pay WFG or the product providers any consideration for not purchasing a product or service. Further, in order to purchase any products or service, the agent is not required to be affiliated with WFG or affiliated companies and product providers. So you don't have to be recruited to get a policy from WFG. You can just be a client. The vast majority of people do that. You don't have to be recruited as well. And you also don't get a discount if you're recruited. Like, it's the same price. Like, it's the same product and service. You don't get discounts or marked up for being a client or whatever. It's the same thing that you're going to get regardless. So agent irrevocably consents to and forever authorizes the use of WFG or anyone authorized by WFG as legal representatives or assigned to absolute and unqualified right to use of photographs in which the agent has appeared for WFG. So if you're at convention, they take a picture of you, they're allowed to use that. You're giving them consent to do that, in which the agent has been included in whole or part, made through any media without inspection or approval, the finished product of which it may be applied in any manner WFG may desire, factually or fictionally, including the right to make adaptations to said material of every and any kind of character for the purpose of WFG to obtain a copyright in all countries used by WFG in materials. So basically, if you're on picture or your video or something with them, they're saying that you are waiving your right to be able to not do that. So the agent releases and discharges WFG affiliated companies their assignments, agents, licenses of any other claims and demands that an agent may have, which arise out of or in connection with the use of photography reproductions, including but not limited to any other claims of libel, slander, or invasion of privacy. I wonder if that would be like you told your job that you were sick, right? And then you go to convention and then they see pictures of you at convention. and you tried to sue them for that. I guess that could happen too, right? All right, and in signing this agreement, I hereby revoke and terminate my associate membership agreement or marketing director agreement that I previously signed with World Financial Group or any other predecessor. All right, so there it is. That's the contract. I don't know. What did you guys think? Do you guys feel like there was any gotchas in there? I didn't see anything in there that was like, oh my gosh, GFI was right. They're not going to do anything for their agents. It's a big old setup. They just want you to come in and sell stuff, and then they terminate you for no reason. So I didn't see it in there. It seems like a legit contract to me. I wouldn't be ashamed of having a new agent sign this and get appointed with WFG. Like, it looks like a normal contract. It's kind of long, but I don't know. I mean, do you guys feel like there's anything that shouldn't be in there? So now we're going to get into, and I know we're running long. We only got like 15 minutes, so we might have to put this off for another one. We got a little bit longer than that. But in our next segment, we're going to be talking about some of the paperwork that you get through WFG and some of their kind of like best practices. And so this is what the agent receives. I believe it's in their email, and I think they have they have a way to get it through their platform online. And this is what they're basically going to see in it. I think it's kind of a way to like what you should do, what you shouldn't do, and I think it's a good insight to WFG and how they handle their business. Like what do they expect the agent to do? What are you kind of required to do? What are their expectations for how you should perform? That whole best practices aspect of it. So we're going to skip this little section here. Actually, let me flag this so I can properly switch. All right, cool. So we're going to skip this. This is all the GLBA and HIPAA stuff. So it's going to be normal HIPAA requirements, but you're agreeing to all that stuff too. Cybersecurity, make sure you're careful with people's socials. Don't be emailing that stuff around. Make sure it's, protected. Fair Credit Reporting Act, so they're going to pull your credit score, see if you've had bankruptcies, other financial issues. That's all pretty standard stuff. Again, you can pull all this up on locals.com if you want to see this stuff in detail. This is what the actual agent sees. Fill out your name, your social, fill out your W-9. All right, agent insurance guide. So this is going to be a good perspective into WFG and kind of what their feelings of how their agent should act, and really the best practices. So thank you for choosing to be licensed with WFG. If you're in California, doing business as World Financial Group Agency, LLC, I guess it's got a little bit different of a name there, World Financial Group Agency of Hawaii, Insurance Agency of Massachusetts, so it's got some different names depending on the different state. Our standards are high. And I think they should be in the industry. I think that we've got an obligation to do what's right for the client. And I think sometimes that gets forgotten. I think we forget sometimes. I think we are probably the biggest issues in our industry. I think the way that we treat each other this really needs to be resolved. I think the way, like all the stuff that you read online, I'm really irritated. Like the Life 180 guy, was the other guy, Dumont, something like that. Every video they post is this a pyramid scheme? Is that a pyramid scheme? Is this that? And then the whole time, as you watch those videos, as it gets to the end, it's why you should get recruited into their team and their company, right? And it's like, I think we need to do a better job with this stuff. We need to raise our standards individually, I think, in that we're careful of how we speak about each other and what we say to each other. I know that probably won't happen. Maybe that's a pipe dream. Maybe that's just what I wish would happen. But I think we do the vast majority of the damage to each other's companies way more than any client or disgruntled recruit ever has. The vast majority of the stuff that you find online is from agents or people in the industry, which I think is horrible. It's terrible. So anyway, offering the right products and services to the right people in a professional and transparent manner helps ensure that you and the company are successful now and in the future. As you build strong businesses with your clients and look to address their financial needs, remember that even though you are in business for yourself, there's a team of individuals ready to assist you and answer your questions so that you always put the customer first. And this has been one of my favorite things about the industry. When I was in engineering, I also did some work in computer programming, and there is no support whatsoever. You're kind of like on your own. You got to figure it out. But I think that comes with having the agreement that WFG and these companies have, is that you're agreeing to work alongside each other, that we're going to help each other, but that also comes with restrictions, right? Like, same thing in a marriage. You're saying we're going to do this thing together. So there are going to be times where I'm going to do things that are not in my best interest, but that are in our best interest. And that's supposed to be the conduct of how you operate, especially inside of your company and inside of the industry. And this whole lawsuit thing has been a breach of that. And it's been a breach of, we're going to work together and we're going to build this thing together and we're going to help each other through this process. And my feeling is that Eric and that whole group, at least from my understanding from the WFG people, is that they broke that. And so some of that success being, and I'm not saying all of it, Eric is still probably a fantastic leader, but in part has been due to taking advantage of that system where you're working inside of a group of people who promise to not steal from each other. And yeah, you can go in there and make extra, like think about the US right now, right? Like you could right now, because our laws are so laxed, you could get ahead financially. You're legally allowed to walk into a store, grab under $1,000 worth of stuff, and walk out, and they're not going to do anything to you. So you could do that and get ahead, and then you go, well, you know, like I'm getting that money, right? And our whole society right now seems to be, oh, well, they got the bag though, right? So it must be right because the proof that it's right is that you made money. And I disagree with that wholeheartedly. That the aspect of that agreement is that we're going to do what's best for each other in the long run, which sometimes means sacrifice in the short run, which I think is why this business is hard, because we're rewiring people to go from acting in their own best interest the vast majority of times to then acting in the best interest of a team and a company. And that's not easy to reprogram people to do. Anyway, off my soapbox, but I think that's why this industry is more challenging, simply because of the mindset change that has to happen in working as a team versus working independently. And most people come from a background where they work in a place. When I was an engineer, you had to protect your space. You didn't go outside of your box. You didn't help anybody else. You had to fight for your own space. And the way you get a promotion is by not assisting other people so that you can look better. And in this industry, it's the exact opposite of that. So it's important to understand the requirements of local, state, and federal laws. It is up to you to familiarize yourself with any of those rules and applying to being an insurance licensed agent and conducting business. You should also be mindful of any requirements in your contract with product providers. Maintaining high ethical standards can not only help you exceed client expectations, but they also can help you protect your business from potential client complaints. Excuse me. Thank you for your commitment in making this company a unique and successful organization and for adhering to high standards. Committed to following ethical principles, conducting business according to the highest standards of honesty and fairness, treating clients as we want and expect them to be treated. Like, fairly, the complaints that you find online are when this stuff is not followed. Right? IULs can be great. Permanent insurance can be great when you do it right. But sometimes people can look at the commission over the mission, and that's when it starts to get in trouble. And so the complaints about the IUL are entirely true. It's because it wasn't sold well. It wasn't sold right. It was sold to make a larger commission than it was to actually do a good job for the client. And that's not WFG standard. Like that's an industry challenge with not teaching your people best practices. Providing competent and client-focused sales and services. Competing fairly is the question right here, right? Is it fair that you're going to a group event and then your focus is to recruit as many of those people from other people inside of the company? Is that competing fairly? Providing advertising and sales material with content that is clear, fair, and does not mislead. Handling client complaints and disputes fairly and promptly, right? Like, one of the things I think is funny too, they're like, oh, well, people have complained about the company. There's like 25 complaints or 50 complaints that I found online. I'm like, oh, that's great. They do like 500,000 clients a year. Like, you could talk to your I bet you there's somebody in your family that doesn't like you, and that's out of 15 people, right? There's probably one or two that don't like you. Imagine, and that's just clients, 500,000 clients, and then so it means they talk to more people than that, right? So to have somebody that you disagree with or that something comes off wrong or whatever, of course that's going to happen of a company of that size. Maintaining a system of supervision and review that is reasonably designed to achieve goals. So they're going to get into all these different topics. Ethics, sales, practice guidelines, basing the sales on the client's needs, that's a huge one. Fact-finding, selling to senior adults. We'll probably breeze through a bunch of this stuff. State specifics, of course, California is different for everything. Soliciting to military personnel. Life insurance as a tool to meet our clients' needs. Long-term care, annuities. All great stuff when it's done right. Like, I think our industry is the most impactful in somebody's life when it's done right. It's the difference between them on the, and I don't know what it is, but at this particular street corner, there's no other beggars except for every single week, every other week, it seems like somebody has passed away without life insurance and they're standing out there with the signs. And for a couple dollars a month, somebody can protect their family from having to go out and beg on the street corner because their loved one passed away, or being prepared for retirement or their long-term care needs. I think what we do is great, and I love this industry. I think it's one of the best industries to be in if we treat it right and we treat each other right, which unfortunately we're here because that's not how it's been happening. Training and education, making sure you have your errors and omissions, anti-money laundering, trade practices, quick reference to do's and don'ts. So you have all of this on Locals. Again, you can go download it for yourself and go through these things into whatever detail you want to at that point. How to advertise, marketing guidelines, product advertising. And we won't go through all of this. Obviously, it talks about insurance fraud, anti-bribery, anti-money laundering, handling complaints. They're pretty rare, but every once in a while you just catch somebody on a bad day. And it's usually I don't know why, but it's always the ones that you go out of your way that you don't really even want as a client, but you feel bad for them. And so you spend way too much time and way too much effort to help them, seem to be the ones that get you in trouble for helping them. Ethical sales and practice guidelines. Before you make calls or schedule a meeting with your prospect, do your homework, educate yourself on the responsibilities of an insurance professional and doing business the right way, and make that a priority. Be prepared. Offer those products and services that you're authorized to sell, right? Don't talk about stuff that you're not supposed to do. Make sure you're properly licensed and appointed in the right state. Do your special trainings. Talking about annuities, there's trainings, index products, there's trainings, so many trainings. I feel like we do so much training sometimes that it's hard to actually get any work done. That's not entirely true. But it is a lot. It's mind-blowing how much training that you got to go through to be good in this industry. Know your products. Only offer those which you have significant knowledge, training, and experience. When meeting the client or prospect, identify yourself as a life insurance agent with WFG. Begin your relationship with trust and transparency, which again becomes a question of if you're doing the anchor leg strategy, you're kind of already breaking that trust from the beginning. Know your client. Knowing your client and understanding their needs is important. You should always perform a thorough fact-finding and needs analysis. It was interesting to me to find out that some companies don't do that. Some companies will just flat out give you an insurance policy and they don't do any kind of financial needs analysis. I don't know, it's crazy, but apparently you can do that. So presentations and proposals, put the client's needs first based on any recommendations of the client's circumstances and objectives, maintain notes and other documentation supporting recommendations. Use only WFG approved sales materials. Use words, terms, and symbols that accurately describe the features, right? Don't lie. Avoid incompetent or misleading statements. Accurately and comprehensively disclose all relevant information on products and services. Explain in a balanced and fair way the products, procedures, benefits, loads, fees, limitations, charges. Fully explain the hypothetical nature of illustrations, right? Illustrations are wrong 100% of the time. 100%. It's never going to be just like that. Point out their assumptions and limitations. Be sure to explain the difference between guaranteed and non-guaranteed elements. So I think when this stuff is done right, like, oh my gosh, we can do such a good job for people if we just do it right and we don't take shortcuts. Policy replacements should only be considered after, this comes into the churning aspect, right? Policy replacements should only be recommended after careful, thorough, well-documented analysis has been done by an agent comparing the short and long-term advantages and disadvantages to be a client. Be familiar with the replacement equivalents in the state. I'm sorry, I got to call out Primerica here. You guys are horrible with this. I don't know if you guys have provision like that, but I bet you do. You guys are some of the worst. I know you get terrible training on permanent policies, but you guys have caused a ton of damage to families canceling their permanent life insurance policies because you don't understand how they work. I've literally done a policy for my mom. I think it was a nationwide long-term care policy, and I was in a dispute with a Primerica person. They're like, that policy doesn't exist. That's not how they work. I'm like, I'll get the policy and you can come see it. They never actually showed up for that meeting, but you guys are some of the worst when that goes. If you would actually understand how permanent policies work, you at least wouldn't replace them. The ones that are built, here's always the caveat, the ones that are built right? Adhere to all state best interest and suitability regulations, comply with WFG's process, confirm the client's reasons for purchasing, reconfirm financial objectives, product addresses their needs, provide the client with a copy of any sales illustrations, provide the copy with any state mandated notices, review with the client any state mandated or otherwise disclosed forms, make sure the client carefully and thoroughly answers all questions on the application, instruct the client to make check payable to the insurance company, not yourself. You should not be accepting checks. Following your meeting promptly upon the application submission, replacement forms if applicable, premium history with the company, provide copies, okay? We'll kind of skip through some of this stuff. Know your limitations, tax and legal advice. We're not tax consultants. If you're with WFG, if you're insurance licensed, you're not a tax consultant. I'm not a tax consultant. I don't have my CPA license. So you can talk, it doesn't mean you can't talk about taxes. You just got to be careful in the way that you talk about it. Policy delivery, why it's important. Make sure you're doing it promptly. Deliver it in person. Require that you deliver the policy to the client and you make sure they actually have it. Obviously, a lot of this stuff is self-explanatory, but I think it's important because you can see the background of what the company is supposed to be like. Obviously, when you add people, things change because people don't always do what they're supposed to do. But what is the client investment time horizon? That's important. Determine the client's risk tolerance. Ensure the premium is affordable for the client, that you're doing the right thing. Fact-finding. Actually gather information, figure out what your client needs. Selling to senior adults has special requirements to it as well. Be careful using specific titles with them. Don't use high pressure sales tactics and creating a sense of urgency. Suitability, make sure it's suitable. They have additional state laws that are important as well. Look for diminished capacity if they have issues where they can't understand simple concepts or they seem confused, afraid, or nervous. Don't sell that policy. Suspected abuse or financial exploit. If they're being exploited, you see that happen a lot of times too. We've got clients that are in the healthcare. It's crazy how many times the healthcare people are stealing from them or changing forms without them knowing, whatever it might be. It's kind of crazy. You got to be careful about those things. California, special requirements. New York, special requirements, of course. Solicitation to military personnel is different as well. You got to be careful with a lot of that stuff. Life insurance is a tool to meet clients' needs. Generally, life insurance death benefit can address different situations, burial expenses, income continuation for the family, college funds, retirement funds for a surviving spouse, asset protection, debt coverage, accelerating death benefits, excuse me, for terminal illness, business planning, estate planning, etc., determining the death benefit needs, long-term care. Right, so I think it gives a good outline on actually what's expected from the agent and how they're supposed to handle themselves. Annuity is a tool to meet the client's needs. Calculating the needs for annuities, what's their financial status, time horizon, risk tolerance, right? These are all the standard guidelines of, at least what I was taught in industry. I don't know what other people get taught, but a deferred annuity, a qualified versus non-qualified, policy regulations. Again, consumer rights, this goes back into that personal information aspect, what you do with it. Delete that information, don't keep it, right? Make sure you're careful with that. Be free from discrimination. Health insurance. I don't think they sell health insurance though, but maybe if you sell them also. License and appointments, make sure you're set up in the correct states. Go through appropriate background checks. Anyway, it all looks pretty standard to me. You got to make sure you carry your errors and omissions. How to handle non-licensed staff, right? What are the things that they can do? Do not let your non-licensed or your assistant can't take applications, can't deliver policies, can't discuss or explain terms or policy features, conduct seminars, rate quote. Interesting, that's considered consolidated. I mean, not that I have, but it's interesting that that's considered. Just running an illustration even. Cannot conduct product provider, cannot contact product providers. Education and training. How to go through, you have to do your ethics and compliance training, meet the training standards, do your continuing education, security with information like phone numbers, social security numbers, account numbers, right? Because you get bank account numbers, all that kind of stuff. Driver's license information, physical security standards, electronic records. Quick do's and don'ts, that would probably be a good one too, but we're running out of time. So again, you have all this on locals. You can go download this and go through this on what to do, what not to do. Can't give gifts more than $100. Don't use your securities accounts for personal business. They hate that. Don't tell them that it's a franchise opportunity, right? Just being transparent. I think that people need what we do, and so you don't have to lie about it. You just got to be honest in what you're doing. Telemarketing issues, email marketing, client funds. Don't mix those with your funds. Policy replacements, on how to actually do standards with that. I guess New York has even additional guidelines. Insurance, annuities, long-term. Sorry, I'm going through this fast, but you guys get the gist of it at least, hopefully. Index universal life, that's a big topic that's out there. Clearly describe that all life insurance product is designed to provide life insurance protection. I think sometimes people forget to mention that, right? It's life insurance first. It has other great features, but first and foremost, it's life insurance. Clearly disclose that the insurance company is an entity backed by guarantees that provide the product. Clearly disclose that the product is not an investment, which is tough because I think that you have to have an investment mindset to put it in there, and I had a debate with somebody on that the other day, but that's for another topic. Do not place undue emphasis on the index. Product advertising, how to do all of that. Lifestyle claims, is a big one too. Got to be careful with that. It was, I did a video on, oh my gosh, what the heck was that company? FFL, that they got a cease and desist letter because they were doing some stupid stuff like that on social media. Instructions for advertising review. Anyway, so like you get general gist on all of that stuff. I think that don't commit insurance fraud. I mean, standard stuff, like just do what you're supposed to do and don't defraud people. Watch for anti-bribery and corruption, anti-money laundering. Anyway, we're gonna wrap that up. There's another 20 pages that we didn't go through. Oh, and then the arbitration agreement. So I apologize, we're not going to run through that again today. If you want to watch that, that's in the video from Wednesday. If you want to see what's in that arbitration agreement, basically it's just saying that both parties agree that no matter what happens, it's going to go through arbitration. That's the first line of defense. So if there's any kind of litigation or anything that's going to happen, it should go to arbitration first, and then they'll figure out what's supposed to happen about that. And so that's kind of where we're at with that lawsuit where Olson is suing WFG. WFG is saying that they want it to go to arbitration because that's the way that they agreed that it should go first. Of course, they don't want that to happen, partially because I think then it ends up in Georgia. So that makes a big difference. It's also hard, from my understanding, to get any kind of damages out of it. So if they do go into arbitration, it's going to be hard for them to claim that they need additional funds or that this has been stolen from them, their code number's been stolen, all that kind of stuff. So they obviously want to stay out of arbitration, but we'll see what happens with that. So anyway, I appreciate you guys. I hope this was helpful for you. I hope you get a lot of information from these calls. You guys have been awesome. I think we've had over 100,000 views on these particular things. So if you're in the industry and you're trying to figure out what to do, I get those messages all the time. You know, I was formerly with WFG. My people are gone. They've been stolen over to GFI. What do I do now? Or you're kind of like straddling the fence. You don't really know what to do. I hope these have at least been helpful for you or your team in figuring out what to do and where you should go and spend the rest of your career. So anyway, I appreciate you guys, and we will have to get into that, that reply for the arbitration on sometime next week. Maybe we'll do Monday or Wednesday. So I'll let you guys know as soon as I have that. So anyway, make sure you click the bell because they are limiting all of our stuff on social media. So you're probably not getting much notices. If you're not subscribed, you haven't hit the bell yet, you probably won't find out that these things are happening. But I appreciate you guys. Hope you have a great weekend. It's Friday, so hope you have a great one. Marlene and I have a pickleball tournament tomorrow, so that's going to be kind of cool. We're excited. So anyway, appreciate you guys. Catch you all later. Bye.